Yeah. Welcome to Expert Views on ADR Ever, a podcast about simplifying alternative dispute resolution in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, postdoctoral fellow at the University of Brighton, United Kingdom, and a fellow of the American Bar Association section of dispute resolution. I am delighted to welcome Jo Colbert Stanley to the EVER show. She is a Florida Supreme Court qualified arbitrator and certified circuit civil and county mediator. Jo has practiced law for over 20 years, focusing on the areas of labor and employment, insurance, defense, ADR, and human resource diversity and sensitivity training. She's currently pursuing her PhD in conflict analysis and resolution. Jo wears many hats, so I've left the link to her profile below. Welcome to the show, Jo. We stop sharing now.
Thank you. Thank you. Thank you for having me.
All right, so I think we wasted time, so without further ado, the question one is, how far has ADR been able to enhance access to justice in the US, using Florida as a case study?
Oh, I think it's done a great job. Of course, you know, what we call now ADR has been around for centuries, millennia, well before, you know, what we see now as a more formalized use of ADR methods. But I do, in my practice, I see the, I would say, relief on a lot of faces of people who would otherwise not have their, quote, day in court because of the informality and the economics, frankly, of ADR formats that are able to have their, you know, their disputes resolved or at least heard. And so I think it's done a wonderful job. And in part, that's due to the overwhelming adoption by formal dispute resolution services, such as courts and litigators and judges and whatnot, who have, you know, come to accept that, you know, not everything needs to be litigated and fought tooth and nail in front of a judge in robes, so to speak.
Yeah. So how about lawyers? Have they embraced ADR?
I think so. Yeah, I think so. I mean, you'll always have attorneys who I like to say would prefer to earn their pay in more traditional settings, such as in the courtroom, the aforementioned courtrooms. But I think attorneys are recognizing that, for example, with mediation, it's a good opportunity to you know, present their clients' cases and have the ability to perhaps resolve them in more creative fashions. But yeah, I think in general, attorneys do adopt the ADR, at least as a step in the process. Even the most reluctant ones acknowledge that there's a value to at least, for example, going to mediation beforehand.
Yeah, all right. So is there any measurable difference or impact on the cost and time frame for settling disputes compared in ADR compared to litigation?
For sure. You know, and there's definitely research and statistics on this. You know, even using arbitration, you can generally expect a result, depending on what institution, whether you're doing an ad hoc arbitration versus an institutionalized arbitration, but generally you can expect to have your case resolved at least a year before it would be even set for trial. And in Florida, you know, and I think this is true probably across the United States, I can't speak internationally, but court dockets are notoriously overcrowded. And so there's a delay sometimes in getting hearings set and getting trials set, and, you know, extensions and then another extension. But with arbitrations and mediations, you know, generally once the neutral sets the date or the parties have agreed on a date, it goes. So it definitely speeds things up, and there's definitely a financial benefit Attorneys are going to charge what attorneys charge anyway in terms of their time, but you're certainly saving maybe on costs of court fees and whatnot. But what's important to note in many, especially commercial enterprises, even though you're paying for a court or you're paying for an arbitrator, for example, and you're paying your attorney's fees anyway. So you may say, well, is there really a difference? Is there really a cost savings versus going to court? It's important to point out that the delay of going to court and going to trial, and then after trial, let's not forget, an appeal and the whole appellate process, that timeline has an expense in and of itself, especially for commercial enterprises where, you're not getting a resolution of the matter. So assets may be frozen, or products aren't getting off the shelf, or contracts aren't being honored and services aren't being performed. So the delay is a huge, has an impact on costs that alternative dispute resolution mechanisms avoid, or at least ameliorate.
All right, thank you. So in relation to workplace conflict, the workers or employees are aware of ADR options, of settling this.
Yeah, well, that'll depend on the employer, right? So, yeah, and in those cases, I see more and more a corporate trend, of course, towards in-house mediation. And there's a school of thought that in-house mediation or in-house dispute resolution is improperly imbalanced because, if it's being run by the corporate, quote, mediator, there may be a perception of bias. However, and I know individuals who do this, and that bias is a perception, it's not real. And I think that employees who work in corporations that do have in-house dispute resolution mechanisms available to them take advantage of them. But, each individual is going to have their own perspective as to whether or not it was an impartial process.
Yeah, okay. So to what extent are employees encouraged to use to settle their disputes or to settle discrimination, bullying, or harassment with ADR at the workplace?
To what extent? Again, that's all. Yeah, that all depends on the corporation.
Okay.
Yeah, it's very employer specific. And I think larger companies, the Fortune 500 companies and what have you, have aligned themselves more increasingly, of course, with DEI efforts and more creative ways of handling in-house disputes, in particular between employees, sort of peer-to-peer mediation techniques and what have you. But it's very specific to the employers and the corporate culture in general.
Okay. Do you know anything about private organizations? Is there any body that regulates their policy?
That regulates the policy of the
when it comes to settling disputes, via ADR.
For employers, I can't think of anything. I mean, obviously here in the United States, we have EEOC, the Equal Employment Opportunity Commission, that has a fairly stout framework for how, not only administrative steps, but the in-house steps that need to be undertaken. And certainly, with presidential laws, there's understanding by employers of what measures they would need to have in place to show that they have been fair to their employees. So yeah, you're looking at agency regulations, you're looking at laws. Obviously, we've got our anti-discrimination laws here in the United States, civil rights laws and what have you. So all of those things create, by virtue of the text of them in some cases, they create a framework, an architecture which guides employers and corporate interests in how to handle employee matters. And for labor, that's a whole other ball of wax with the NLRB as well.
Okay, okay, thank you. So why is ADR more prevalent or popular in the more complex society, in this context, US as the developed countries, than it is in the less complex societies? And yeah.
Right. So I think, it's a matter of semantics for me,
Yeah.
in the sense that we say it's more popular, but how do we know?
Hmm.
Who's really, as you yourself know, as a
Yeah.
doctor, the statistics can be, skewed to any side.
Yeah.
So if something's not being measured, does it not exist? I don't know, right? So
Mhm.
it's that whole thing. If
Yeah.
the whole thing, if a tree falls in the woods and no one hears it, does it make
Yeah.
a sound?
Yeah.
So I don't think it's necessarily fair to broadly say that
Mhm.
ADR
Mhm.
mechanisms are more popular in complex societies.
Mhm. Mhm.
To the contrary, I believe that, in what we consider less sophisticated
Mhm.
societies, they probably do, ADR techniques by habit, by
Yeah.
default, because
Yeah.
they're not going to powdered wigs and oak-lined courtrooms to
Yeah.
have their, and like with arbitration, right? We know that there's actual documents showing
Mhm.
that there was private arbitration all the way back into 300
Mhm.
BC.
Mhm.
And that's just the first recorded
Yeah.
type of arbitration. So we don't know from what's not recorded, but there's
Yeah.
always been an indication that folks have managed to resolve their disputes informally without lawyers
Informally, yeah, yeah,
for,
yeah.
for
So
millennia.
I think, yeah, I think you're quite right. Well, however, recent research I conducted, and some other people has indicated that this is more like lawyers embracing ADR. In developing countries, they're yet to come around, and even users as well. When statistics collected indicated that in the more developed countries like UK, there are more people utilizing ADR than it is in the less complex societies.
Mm-hmm,
Yeah,
mm-hmm.
India and Ghana and Nigeria. However, like you said, the traditional method of settling dispute had always been there,
Yes, for
before it was
sure.
formalized and, brought
Yeah.
us this modern ADR. So yeah, anyway. All right, thank you so very much. So what is the way forward for mass advocacy or awareness of the benefits of utilizing ADR?
That's such a great question. I
Yes.
think that, the way forward, it's especially and if we want to use the term complex civilizations, but definitely in the West,
Mm-hmm.
we're a results-oriented culture. And I think the way forward is going to be based on results. And the more people who, whether they're quote unquote forced into ADR, which is anathema to ADR to begin with for most of us,
Yeah.
but the more people who experience mediation or early neutral evaluation, as you mentioned, collaborative techniques and so forth, and are exposed to it and see the benefits, that spreads, right? Because they walk away going, oh, you know what, that worked. That wouldn't have happened if I'd gone to a courtroom.
Yeah.
So it's a matter of exposure, it's a matter of results, it's a matter of experiences. And we just have to keep doing exactly what you're doing, Dr. Chinwe, where you're publicizing it, right, and getting the word
Okay.
out there. And it's part of the marketing of ADR in general.
All right. Thank you so very much. So, what type of mediation is best suited for workplace? Um,
Yeah, that's a great question. I am not a fan of, or an advocate, which is inside joke, but having these pigeonholed types of mediations for each
okay.
solution. I'm very a bespoke. I consider myself a bespoke neutral, in the sense that it depends on what shows up.
Mm-hmm.
What's
Yeah.
presented before me. If we talk about traditional styles of mediation, that we learn about, like narrative, transformative, problem solving, those different types, I find that it's always a blend that's necessary.
Yeah.
That you may walk into a mediation where you think,
Yeah.
well, this one's a numbers crunching style mediation. It's based on a dispute in a contract clause or whatever. And so we're going to go problem solving style.
Yeah.
But then when you meet the individuals, you meet the personalities, they may be more inclined to a collaborative process, you know, based on, you know, more transformative even techniques. So I'm loath to say there's one particular type for workplace disputes that's better over the other, but I certainly think that given the likelihood that the employees will have to continue working with each other, you do want some form of a narrative technique where people get to tell their story, get stuff off their chest, and hopefully, you know, with a dose of transformative in there where they can sort of stop seeing each other as adversaries and develop a team mindset.
Okay. All right. Thank you. So So what does yacht mediation entail?
So yacht mediation is,
and that's the first time of me hearing, so I'm really eager.
For starters, I'll say this, that yacht mediation, particularly private yacht mediation, which would be my sort of niche, if you would, but it's something that happens very informally anyway. And if you go to any boatyard, there's some level of mediation happening. And this is where I sort of leaned into when I was talking about less complex civilization societies, using alternative dispute resolution. The reason being that in the yachting community, it's a very tight-knit community. And although, as I've said before, it's a far-flung community because we travel, it's very transient, people come and go. But at the end of the day, there's a certain level of camaraderie that underlies even the most adversarial relationships in yachting, because you know you're going to need that engineer, or you know you're going to need that captain or that boat painter, or there's only one guy who really handles those electronics. So what it looks like is a lot of I would say rolled up sleeves, and you know, my late father-in-law would call it head bashing, where you just kind of get people in a room and go, look, you know that you need each other, so what's the problem here? And it's very blunt and realistic at the same time. But like I said, it happens nonstop. If you go in a marina, if you go in any working boatyard, and of course, I'm on the International Yacht Arbitration Council for the International Yacht Brokers Association. So there's some more formalized, you know, processes where you're dealing with purchase sales agreements and whatnot that look more like your traditional mediations in rooms with individuals dressed in coats and ties. But like I said, because it's based on ongoing relationships, and in many cases that need for confidentiality is so key, it's very unique, but it's fun.
Oh wow, that's interesting. And sorry about the lights. It's
it's okay.
So finally, not finally, sorry. So what is your advice for people pursuing a career in ADR? Mediation arbitration,
I think the first thing you have to look at is your timeline. Mediation, ADR, whichever route you go, if you're MedArb, if you're ENE, what have you, it's not something that happens overnight. You know, we always talk about it being a long game. And so I think if you're pursuing that, you know, as a career at the outset, get your training in order, because that's going to, you know, be the first step. Everyone's going to look at your credentials. And again, if you're, of course, in a state like Florida, where we're pretty heavily regulated and proud of it, you're going to have certain classes you have to take and observations and so forth. So the first step, of course, is to get your training done, and stay training, constantly training. Don't ever think, oh, well, now I know everything. You don't. You know, you keep on learning. You go to all the CLEs, continuing legal education, or CMEs, continuing mediation stuff. But recognize that it takes time. It takes time to not only develop your craft, It takes time to develop your network. It takes time to develop your, I think, style, to where, you know, you're not just necessarily doing what you learn in the books or learning your training session, but you're learning what works for you. Because the key to being, I think, a successful neutral is being authentic, to your personality, to your notions of fairness, to your notions of, you know, everyone, there's two sides to the story, that kind of, you know, perspective. So it takes time to get to, I think, to mature into that role and feel confident about your perspective. So the key is patience and training.
Yeah, and training, yeah. So constant training, and
Constant.
yeah, your timeline as well. So yeah.
Yes, yeah. Just don't think that it's going to be, oh, I'll get my certificate and tomorrow I'll open up my shop. That's not like it doesn't happen that way at all.
It doesn't work that way.
No.
All right, thank you. So can you tell me more about Stanley Legal Services and your thesis as well?
So my Stanley Legal Services, which was renamed 5 years ago, interestingly, of course, LinkedIn said, hey, congratulate Jo on her new job. It's new name. But so been around for about 20 years. I've primarily worked as an independent consultant for other law firms, doing contract work, coming in on special cases. I would say places where it didn't necessarily fit into the firm's overall, you know, scheme or what they did most of the time. But here it's maybe it's a client that they value, but it's not the type of case they normally handle. So I come in, and then of course with my neutral practice. So that's Stanley Legal Services. We're just, as the tagline says, here to help. So just sort of roll up my sleeves and do what I have to do. I think you asked about my dissertation. As you know, that topic is, I have a t-shirt that says questions you don't ask a PhD student, and one of them is, what's your dissertation about? But I am in my third
summarize
year.
It, yeah,
in my third year. So what I'm looking at right now is the relationship independent contractors in private yachting have with ADR processes, their access to justice, their ability to invoke mediation or arbitration clauses in their contracts to the extent that they have them. But in general, just to see what's going on with independent contractors, because I have a feeling, as the owner of an independent contractor company in yachting, that oftentimes independent contractors are sort of left out of the dispute resolution facet in private yachting due to the nature of maritime law in general. So, but it's an evolving topic, my dissertation. So we'll see how it all plays out when it's time to defend my research proposal.
Yeah. So what methods and methodology have you employed? So
to everyone's horror, I'm going to be doing a mixed methods approach. So yeah, there's going to be interviews, of course, a qualitative and analysis, because I do believe in, you know, the phenomenological aspects of getting. You need to know what people are experiencing, and I don't think statistics are enough. However, that said, I am going to go deep dive into the quantitative analysis as well, and run my surveys and see what answers I get back. So yeah, it's mixed methods. It's going to be a hot mess and lots of fun. But my dissertation is
I think it's
my committee chair, Dr. Mary Hope Schwobel, is very confident for both of us that we'll be able to pull it off. So, but it's going to take a while.
Good luck.
Thank you. Thank you so much.
And if you need any help,
yes, exactly. I'll be hitting you up.
All right, thank you so very much, Jo. It's so nice having you on the show, and you've succeeded in simplifying ADR in Florida. So yeah, and I also want to thank my listeners that, they're always listening and sending me comments, questions to ask, and, all that, for their constant support. Thank you so much for your support. And yes, same time next week, I'll be coming again on the screen to discuss about ADR and workplace conflict. Yeah. All right. Bye-bye, Jo. Take care.
Thank you. Bye-bye. Take care.
Cheers.